Welcome to the Lawyer's Library. Today, we delve into a significant judgment by the Supreme Court of India, Chatha Service Station versus Lalmati Dev. This case, decided on 8 April 2025, carries important implications for motor accident claims involving vehicles carrying hazardous goods. The case arose from a tragic motor accident where an oil tanker owned by Chatha Service Station caused the deaths of two individuals. These individuals were the sole breadwinners for the families of the respondents, Lalmati Devi and others. Following the incident, a first information report was lodged against the tanker driver for rash and negligent driving. An eyewitness corroborated this account, and the subsequent charge sheet and FIR further supported these findings. The Motor Accidents Claims Tribunal, after reviewing the evidence, found the driver negligent and awarded compensation to the victims' families. However, the tribunal also issued a crucial pay and recover order. This directed the insurance company to initially pay the compensation, but then recover the amount from the owner and the driver. The reason? The driver lacked a valid endorsement on his license to operate a vehicle carrying dangerous or hazardous goods, a requirement under Rule 9 of the Central Motor Vehicles Rules 1989. Chatha Service Station, the owner of the tanker, challenged this pay and recover order in the High Court of Punjab and Haryana. Their appeals and review applications were ultimately dismissed. Undeterred, they then approached the Supreme Court. Before the apex court, the appellant argued that the absence of the specific endorsement was a minor oversight, especially since the accident wasn't directly caused by the nature of the goods being transported. They even claimed the vehicle wasn't carrying hazardous goods at the time, a point later contradicted by the driver's own admission. Furthermore, in their appeal to the High Court, the appellant produced a certificate claiming the driver had completed a 3-day training course. This brought forth three key issues for the Supreme Court to consider. Firstly, did the lack of the mandatory endorsement under Rule 9 constitute a significant enough breach of the insurance policy to warrant the pay and recover order? Secondly, should the training certificate, produced for the first time in the High Court appeal, be accepted as valid evidence? And finally, did the absence of the specific endorsement contribute to the cause of the accident itself? Representing the appellant, the owner argued that the breach was minor, as the accident wasn't related to the hazardous nature of the cargo. They cited previous High Court decisions to support their claim that the insurer needed to prove the breach was fundamental and directly caused the accident. They also emphasized the belatedly produced training certificate as proof of the driver's competence. The respondent, the insurance company, countered by highlighting the strict requirements of Rule 9 and Section 14 of the Motor Vehicles Act, which mandate specific training and endorsement for drivers of vehicles carrying dangerous goods. They pointed out the driver's admission that the tanker was indeed carrying oil and that he lacked the necessary endorsement. They also argued that the training certificate was rightly rejected by the High Court due to its late submission and lack of proper authentication. They emphasized that the training mandated by Rule 9 goes beyond just spill management and includes crucial driving skills for such specialized vehicles. After careful consideration, the Supreme Court delivered its judgment. On the first issue, the court firmly held that the absence of the endorsement under Rule 9 was not a minor breach. They emphasized that Rule 9's comprehensive syllabus focuses not only on product safety, but also on enhancing the driver's skills to handle these specialized vehicles. The fact that the tanker was carrying oil at the time further solidified the necessity of the endorsement. The court even clarified that even an empty tanker designed for hazardous goods requires this endorsement due to its unique design and purpose. They explicitly rejected the interpretations of Rule 9 in the High Court decisions cited by the appellant. Regarding the training certificate, the Supreme Court upheld the High Court's decision to reject it. The appellant had failed to provide any explanation for not presenting it before the tribunal. Furthermore, the certificate lacked key details like a serial number and institutional seal, and the driver himself never mentioned undergoing such training during his cross-examination, casting serious doubt on its authenticity. On the final issue of whether the lack of endorsement contributed to the accident, the court, referencing its earlier judgment in National Insurance Co. Limited v. Swaran Singh, reiterated that the absence of a license for the specific vehicle type must be a primary or contributing factor to absolve the insurer. In this case, the evidence clearly pointed to rash and negligent driving as the cause of the accident, supported by the eyewitness and the charge sheet. However, the court also highlighted that the driver's lack of the required endorsement meant he was not authorized to operate a vehicle demanding specialized skills. They dismissed the driver's claim of swerving to avoid pedestrians, finding it contradicted by the eyewitness testimony. Ultimately, the Supreme Court dismissed the appeals, thereby affirming the pay and recover order issued by the tribunal and upheld by the High Court. The insurance company was directed to compensate the victims' families and then recover the amount from Chatha service station, the owner of the oil tanker. The Supreme Court's decision underscores the critical importance of adhering to the statutory requirements outlined in Rule 9 of the Central Motor Vehicles Rules. It emphasizes that these regulations are in place to ensure both driving proficiency and the safety of handling hazardous goods. Non-compliance is considered a significant breach of insurance policy conditions with serious financial consequences for vehicle owners. This landmark judgment serves as a clear reminder of the responsibilities of vehicle owners and the necessity for drivers to possess the correct and valid endorsements for the vehicles they operate, especially when those vehicles pose inherent risks due to the nature of their cargo.